Good evening, everyone. Thank you for joining us for another WAND forum. This evening's topic will be deconstructing the laws governing incarcerated children in Barbados and Jamaica. A warm welcome to all of you listening in and watching via our online channels. A warm welcome especially to our guest panelist, Mr. Alexis Goff, human rights activist and therapist, Ms. Lisanne Taylor, and Ms. Michelle Russell, both attorneys at law, and they have joined us this evening to share their expertise, professional experience, and insight on today's topic. I am Kellyanne Knight, Gender and Development Specialist, currently working with the Women and Development Unit at the University of the West Indies Open Campus as course facilitator, and I will be the moderator and chair for this evening's discussion. To put into context and provide a brief background for this evening's forum on deconstructing the laws governing incarcerated children in Barbados and Jamaica, a lot has been happening in our region around this issue. In recent times, there were reports and many regional conversations around children in the Caribbean not being treated with dignity and were subject to various forms of abuse while in state care. For example, the Policy Research Institute, in their recent report in Jamaica, revealed that between 2006 and 2010, 160 children per year have been physically abused by staff while in state care. And in 2017, the average age for what the report termed intercourse for children in state care was 11 years old. In a sample of 60 girls who were sexually abused in state care, 1/3 of those girls tested positive for sexually transmitted diseases. Another recent example is the ongoing case of children absconding from the government industrial schools in Barbados, and children under state care are being placed on under suicide watch and at the psychiatric hospital. And these followed a series of events within the past 2 years where there were allegations of abuse. Additionally, between April and May 2022, Trinidad and Tobago released their report entitled Safeguarding Children in Community Residence and Child Support Centers in Trinidad and Tobago. And it was discovered that abuse was prevalent at children's homes around the country, where it was mentioned that the culture of abuse was encouraged by adults at these institutions. These reports highlighted acts of abuse experienced by children in state care and included horrendous acts of physical abuse, including instances where residents' heads were being bashed against walls, as well as sexual abuse by adults at these institutions who were placed there to care for and protect these children. As you can see, this is happening in a number of our Caribbean countries, with colonial histories of enslaved people of African descent, where during the post-emancipation period, a lot of these industrial schools were created in the region. Countries that are also signatory to and have ratified the United Convention on the Rights of the Child. Now, when we examine instances of children who are incarcerated, we often hear about wandering. In the reports on the reasons for child incarceration or children who face the law courts, studies show that girls compared to boys account for the majority of arrests for certain types of offenses, including running away or wandering, at least 60%, while on the other hand, boys were twice as likely to be arrested for violent crimes. And the numbers are similar in both Jamaica and Barbados and are consistent with international figures. This issue of wandering often reveals issues of gender-based violence that disproportionately affect girls. This also points to the gender inequalities within our societies. Oftentimes, there are underlying issues that result in children offending, and in the case of wandering, sexual abuse is one that arises, sometimes masked as sexual promiscuity. Another issue highlighted with regard to state care is corporal punishment. Some Caribbean laws outline the ways in which children who come into conflict with the law can be punished and beaten. The UNICEF situation analysis of Children in the Caribbean Report 2019 outlined the repercussions of corporal punishment. It mentions that existing research has found that corporal punishment is likely to have opposite and undesirable effects and can be harmful to children, leading to antisocial and aggressive behaviors. Another area that compounds these issues are the shortfalls and gaps within the legislation and administrative weaknesses within the structure of these institutionalized settings that are responsible for the care and protection of children. Although it was also noted in the report that the OECS governments demonstrated a level of commitment to improving child protection, however, many countries in the region face either delays in passing bills and or difficulties in implementing past legislation, including lack of resources and infrastructure, slow action, and weak adaptation of bills. Before we invite our expert panelists to give their presentations, I want to provide some insight into what our main focus will be today for our evening's discussion. We aim to discuss the dysfunctional laws and legislation governing incarcerated children, its disservice to children, and the changing of these laws, and who has the authority to do so. We want to talk about the interpretation of these laws and who has those functions, as well as who has the authority to alter, delay, or cancel any order, sentence, or instruction. We also want to highlight the use of child labor under the law, and also to bring awareness to these current issues in a way that the general public can understand, especially with regard to these laws, its impact on the children in the Caribbean, specifically for this discussion, Barbados and Jamaica. At the end of our guest presentations, we will be taking questions from the audience. We invite you to place those questions in the comment sections of our live stream in the UWI campus, in the UWI Open Campus, Facebook, and YouTube pages. Let me get right into introducing our speakers for this forum. First, we have Mr. Alexis Goff. Alexis is the son of Susan and Dennis, who loves to drum, especially the djembe drums, and is an educator, trained therapist. Alexis is a member of an anti-criminalization children campaign in Jamaica, which calls for the end to keeping children in police lockups and the repeal of laws allowing children to be kept in adult prisons and being sentenced to life in prison. His entire professional career has been working with children, youth, and their families in schools, prisons, and counseling centers in Minnesota and Jamaica. He has worked with children in conflict with the law and their families in various educational institutions and prisons for over 13 years. Our second panelist, Ms. Lisanne Taylor, has experience as a social worker working predominantly with at-risk youth, both in Barbados and abroad, for more than 12 years before becoming an attorney at law. She has an immense passion for the advocacy of juvenile justice. And our third speaker, Ms. Michelle M. Russell, is a Jamaican attorney at law who was called to the bar in Barbados, bar in 2003. She is a sole practitioner with over 18 years of experience and practices primarily in the area of employment law. She also has extensive experience in insurance and personal injury law and practice, civil litigation, and contract law. Michelle is also a columnist for the Nation newspaper and writes a weekly column in the Sunday Sun that focuses on employment law and labor matters. Michelle also does an occasional podcast for the Nation publishing house entitled Labor Matters. Michelle deems herself a social activist and primarily focuses on issues involving social justice, particularly relating to vulnerable groups, female empowerment, and the disproportionate treatment of the poor, which she addresses occasionally in their articles, podcasts, and other platforms. Now I want to invite Alexis Goff to make his presentation. Alexis, the floor is yours.
Thank you very much, Kellyanne. Let me just make sure before I go on that I can share my screen. So I'm going to do that. Let me know if, what are you seeing? Kellyanne, is that fine?
Yes, that is good.
That's good. Okay, you're seeing
Yes.
the audience view.
Yes. Okay. I'm not seeing you though. I can see your screen. Yes.
Let's just do that for a bit. All right.
There you go. Yes.
Cool.
Okay, you're good to go.
Thank you. All right. Well, good evening, everyone. Thank you so much, Kellyanne, and thank you to the members of the WAND staff at the UA Open Campus for putting on such an important discussion at such an important time in the Caribbean, and especially as it relates to, of course, the challenges, issues, and the struggle for children's rights in the Caribbean. My game plan for today is to talk a little bit about the laws in Jamaica, and maybe we can flesh that out a bit more in the discussion section later on. But I also wanted to focus a lot on some of the points that have helped me in my analysis in the work as a child rights activist in Jamaica, strongly believing now I'm at the point that we need to keep children out of institutions such as prisons and remand centers and police lockups. And so I wanted to start with this image, which was the cover of the issue of the Caribbean Correspondence in June 1975. And you can see right here, it's the image of a child, and the caption at the bottom is, "Look, I'm exactly 6 months old today, and there are many things I want to do." I just want to put this to just situate us in what is important and who we are here for. And here we're talking about children in the Caribbean. So the first thing that I wanted to get into would be the discussion about children and the law. And childhood and the concept of childhood is actually, it has been created and it has been shaped by humans, by people. How we define a child, we might think is because of or informed by like biology or neuroscience or science in general, but that really hasn't been the case. Childhood has been really defined based on a political agenda, and the agenda in Jamaica has been a colonial agenda. And so what is this defined as a child has shifted throughout the years, throughout the decades, and has been defined largely by the Jamaican colonial state to serve the interests not of children and not of their families, and certainly not Black children from poor and working class families, but serving the interests of colonialism, the colonial office, and capitalism. And so treating childhood in relation to labor and in terms of their productivity has been the goal of how childhood has been framed. And so the description of children is really based in like a capitalist colonial framework. And so from this slide, you can see that what we now know in Jamaica as, anybody that is 8 or 17 and under is a child hasn't always been the case. So in the Reformatories and Industrial Schools law, right, a child that is, the reference to a child was a criminal child that was above 10 and below 16. And so 16 and over was considered to be an adult. In the Juveniles Act, which was repealed in 2004, a child, we had 3 categories, right? A child is 13 years and younger, a juvenile is 16 years and younger, a young person was 14 to 16 years. And in the Juveniles Act, 17 years and older was considered an adult, right? In the Bail Act, which still exists, a child is considered under 14 years old, and a young person is 14 to 16 years old. But when we look at now the Child Care and Protection Act, which was passed in 2004, one of the goals was to mainstream or streamline what the definition of child was, and they brought it to what is kind of universally accepted as 17 years and under, anybody under 18 years. But at the same time, right, the laws have determined that the age of consent is 16, yet the age of criminal responsibility, where someone can be charged for a crime, is 12, and that the child labor, the minimum age that a child can start working would be 15, right? So the concept of childhood really changes. It is not, there's no, general consensus about who a child is or what a child is. And it has been framed by an agenda. And I think that's really important to think about. So the point of, well, no, let me do one other thing. Let's also look at law before we go there. Let's look at law. Law also serves an agenda, right? As we discussed in this slide. A crime is determined by humans, right? It's determined by legislators. So for example, we know before the pandemic, the COVID pandemic, it was not a crime if you didn't wear a mask. However, during the pandemic, many countries adopted this law and made it a crime if you didn't wear a mask, right? It's also important to remember that crime and violence are not the same, right? Not all crimes are violent or cause harm, and not all harms are crimes, right? So like childhood, laws and what's considered a crime is not objective in its creation, right? Much less the application of it, which we'll talk about a bit later. So I think it's important as we talk about children and the law and how the laws are created, that we have to think about the fact that, everybody, there is not a general consensus about that children are our future and that we don't want to, we don't want children to be harmed, right? Our laws often use the language in the best interest of the child. And this can be interpreted, in fact, in different ways by different people with different agendas. And one of the things that I think really hampers is challenges or restrains advocacy or activism for children is that we think that everybody at the table has a consensus that we mustn't harm children, when in fact you can have one set of people that might see a problem, right, or a threat, something as a threat to children, or something that is harming children, whereas another set might see that same thing as being good for children. And one of the things that comes to mind when I think about that is corporal punishment, right? So it's really important, I think, in activism for us to understand that, for that to be understood, that not everybody there is not a general consensus about this as it relates to how we treat children and what is in their best interest. So the point of the iterations of the colonial laws wasn't really necessarily to be in the best interest of the child. And it wasn't necessarily for justice or for it to be logical, right? Trinidadian professor M. Jackie Alexander says that the focus of state power is not about being rational or being coherent, right? She says that it is evident from our laws that they are paradoxical, meaning that they are contradictory in ways depending on how the state decides to exert its power. Now, she was talking about, in an essay, in reference to Trinidad and Tobago's Sexual Offences Act in 1986. And Alexander pointed out the contradiction in the act, that on the one hand, the state was in the law trying to police women's bodies, women's bodies and sexuality, while simultaneously trying to build and develop and advertise a tourism sector in Trinidad that was very much focused on and relied upon the sexualization and commodification of women's bodies. And so when I read that for the first time, I remember thinking of, I don't know what to call it, probably a parallel with Jamaica's Child Care and Protection Act. So the act opens with the rationale that the act is in the spirit of the best interest of the child. And there are sections of the act that talk about, consequences, harsh consequences for abuse done to children, right? In the name of protecting children. And in other sections of the Child Care and Protection Act, there are provisions that allow children to be caged in adult prisons, to be sentenced to life without parole, and to be charged for uncontrollable or being beyond control, which is essentially the criminalization of poverty, of childhood, of child sexuality, and of trauma in amongst children in Jamaica. So to the question about why, people ask, like, why are children not important enough for these laws to change, for the systems to change? The answer is that, like, the answer I have right now is that the laws are in line with the goals. That this is not actually something that's necessarily broken or that the ruling class or political class see as broken, because being true to the colonial roots, right, and representing the interests of business class and capitalism in Jamaica, the laws are acting out what the goal is, that they are aligned. What is happening materially to children is in line with the agenda of the Jamaican colonial state. So in the 19th century, there was a commission of inquiry that the colonial office did about the conditions that children were living in Jamaica. And there was a lot of testimony, of course, about the social and economic conditions that Afro-Jamaicans found themselves in, that they were living in. And the report that they released was really framed as a failure of parents, right? And not the economic or social conditions, not colonialism, not slavery, that was enforced by the colonial government. And so the response at that point was to recreate reformatory schools, to place children in institutions, to socialize them, to civilize them, to, in quotation marks, socialize and civilize them, and to learn how to work, right? Again, thinking about their relation to labor, right? Now, the reason that I think this is really important, this is important to know, is not only about the colonial history of Jamaica's laws concerning children, and that this was kind of around the time that we started to formalize the incarceration, the prison system in Jamaica. But also this is where we first see the concept of uncontrollable being mentioned. And so in 1970, 2 years later, 1981, there was a law 34, that created a category of children being beyond parental control and then being sent to industrial schools, right? So this is really the formation of the starting of the formation of Jamaica's formal child protection, in quotation marks, child incarceration institutions, right, or systems. And so this was kept up, right, and withheld and propped up well into the 1950s, where the Juveniles Act was passed in 1951. Uncontrollable was still in the act. Under the Juveniles Act, as with the Colonial Act in 1881, children who were labeled uncontrollable could be placed in children's homes, right, and places of safety. And that was one of the more frequent reasons that they were sent to children's homes and places of safety, common reasons. Now, in 2004, in the passing of the Child Care and Protection Act, which was, lauded, and there was lots of, kind of celebration around it, one of the more heinous aspects of the act was that it started to criminalize or expand the criminalization of children in Jamaica. Now, when I say children, let's also be very clear, because there are colonial laws and founded in colonial laws. We're not talking about all children. We're talking about these laws focusing on Black children, especially Black children from poor and working class families. And what the 2004 Act did was to criminalize uncontrollable, which meant that the court could then sentence children to prison, which they couldn't or weren't allowed to do before. And what we saw almost instantaneously was a dramatic increase in the incarceration of children in Jamaica. You can see that rise there from 128 to 253 2 years later, children incarcerated. And what's invisible from this is children who are on remand, right, who are not in prison, but are in remand centers and are in police lockups for the charge of uncontrollable. And the main reason for the dramatic increase was because more children were being deemed uncontrollable. I just have a couple slides left. I know I'm aware of the time. There's a couple more slides left. And so the effect that this had was that overcrowding started to happen in the child prisons. This was not happening before. And so if you look at 2005, 2006, 2007, the number started to rise. And as you can see now, you started to have children in 2006 being kept at Fort Augusta, which is a prison for women, and Horizon, which is an adult maximum remand prison for men. And the government started to place children in these institutions as a result of an increase in the incarceration of children due to uncontrollable being criminalized. The last thing I will mention for now is that the way that this was framed by the government was not that this is as a result of the passing of the Child Care and Protection Act and criminalizing the uncontrollable designation, but was that juvenile delinquency is going up, that crimes committed by children are just skyrocketing, and we need more prisons, right? We need more space to put the children in. And that, I wish at that time, this is in 2005 and 6, that there were journalists, media folks that were questioning the premise of these statements because it was not true. The numbers, the data did not show a dramatic increase at all of crimes, violent crimes by children. It was a dramatic increase in uncontrollable, which could range from a child not following rules at home, the parents claiming the child not following rules at home, the child engaging in a romantic relationship with someone else that the family did not approve of, not doing well at school, wandering on the road, being picked up by the police. And so this was used, designation was used to incarcerate children who had not, by law, legal definition, committed a crime. And so I think that I just wanted to lay this out before our discussion later, just to hopefully help to kind of reframe and to have us thinking about like challenging some of the thoughts and pre-existing thoughts that we have had about how the prison system and the incarceration legal system works and how it affects children, and to question some of the premises and talking points that we have been given by various public officials, and to dig deeper and to question. And I hope we can definitely talk about where we can go from there in the discussion section. Thank you very much.
Thank you, Alexis, for that interesting bit. It's interesting how you pointed out the conceptualization of childhood and its links to colonialism, as well as the historical context in which these industrial schools were created and how they penalize people of African descent, especially those of poor and working class families post-emancipation, and it's still plaguing our societies today. Thank you for that, Alexis. Next, we have Lisanne Taylor. I invite Ms. Taylor to the floor to give her presentation.
Good evening, Kellyanne and Alexis. Is Michelle here? Because I haven't seen her yet.
Yes, she is.
She is? Okay, well, good evening to everyone.
Good evening.
Michelle is here. Hi.
Well, the question is basically, what role does the law play? And In Barbados, currently, the law that governs juvenile offenders is the Juvenile Offenders Act. And we also have the Reformatory Industrial Schools Act. The Juvenile Offenders Act, that's a 1932 act. Well, it was amended over time. And the Reformatory Industrial Schools Act, this came into operation in 1926. But there were amendments over time, and the last amendment was in 1998. But some of the laws that came down from 1926 still obtained, right? And we're talking about the laws that basically, these are the laws that are used to criminalize our children. The laws that are provided for in Section 14 of the Reformatory and Industry Schools Act. And these are laws basically that criminalizes poor children ordinarily, because you can be incarcerated for something like begging, if you're found wandering, or if you're destitute. So basically the laws that are the provisions in the particular piece of legislation, in the Reformatory Industry Schools legislation, they're all laws that address poverty. That's basically it. And the role now, as it stands in relation to the law, is it imposes more punitive measures when young people come into contact with the justice system. The aim should be more to, yes, maintain public safety, but as well to help with the skills set development, rehabilitation and rehabilitation, and addressing the treatment needs and successful reintegration of our youth into the community. However, we've got substantial deprivation of children's liberties through the extensive periods of long incarcerations, because in Barbados, the legislation basically makes provisions for a magistrate to remand or to send a child to the government industrial school for no less than 3 years and no more than 5 years. So basically what that says is that if I am a child who comes into contact with the law, and for whatever reason I'm going to be sent to the government industrial school, if I'm 13 years old, more than likely I will be sent there until I'm 18, because the law says no more than 5, no less than 3. So that means now that I'm going to be robbed of my childhood, because now I'm spending my childhood incarcerated. And basically for something that ordinarily is not an offense for an adult. So it's important that, legislators pay attention to this. And at this stage where we're talking about reform, and recently our minister, he made the declaration that they are embarking on reforming or revising the juvenile justice legislation. And I'm hoping that this is something that will come into being in very short order, so that we can move away from these old slave laws, because that's what I call them, that basically criminalize our children, right? And one of the questions that we ask is, what can we do? Or what can be done with the limitation in the current laws that we have? And one of the things is that we have to be able to provide access to more meaningful resources. We have to be able to address issues from a systemic perspective, because it's not just young people wandering or engaging in maladaptive behaviors, but we have to look at the reasons why they're engaging in these behaviors. So we have to be able to look at the family structure and be able to approach any kind of intervention from that level, and not just with the child or the young person as an individual, but we have to be able to look at what is going on in the family structure. We have to look at what is going on in the community, and to be able to address all the issues from those perspectives. We need to recognize that at the end of the day, children who commit crimes are different from adults. As a class, they're less blameworthy and they have a greater capacity to change. So we need to be able to create systems and focus more on rehabilitation and not so much on the punitive measures. We have to be able to look at restorative justice in the case of those young people who are coming into contact with the law as a result of being in conflict with the law, opposed to those who are just going into the government industrial schools because they happen to be wandering or they happen to be engaging in, maladaptive behaviors and things like that. So I think that there needs to be a good emphasis placed on resources to help the young people now to be able to function better and navigate their way through the system, right? The juvenile justice system right now, it should maintain rehabilitation as its primary goal and distinguish itself from the criminal justice system. There needs to be more rehabilitation and treatment facilities to provide minors with supervision, guidance, and education. We need to ensure that the youth who come into contact with the juvenile justice system, they have robust and meaningful rights and access to education and developmentally appropriate treatments and opportunities to become healthy and productive adults. Children and youth, they have a vital role in nation building, and we have a responsibility to protect their physical, moral, spiritual, and intellectual and social well-being. So the state has a responsibility to protect the best interests of the child through measures that will ensure the observance of the international standards of child protection. Pursuant to Article number 40 of the United Nations Convention on the Rights of the Child, the state should recognize that the right of every child accused of, adjudged, or recognized as having infringed a penal law to be treated in a manner that is consistent with the promotion of the child's sense of dignity and worth, taking into account the child's age and desirability of promoting his or her reintegration. So whenever appropriate and desirable, the state should adopt measures for dealing with such children without resorting to judicial proceedings. It should ensure also that children are dealt with in a manner appropriate to their well-being by providing, for amongst other things, a variety of disposition measures such as care and guidance, supervision orders, counseling, provision, education, vocational training, and other alternatives to institutional care. But right now, as it stands, in most instances, when a child comes into contact with the juvenile justice system and they're found to be guilty of whatever it is that they've been brought before the courts for, most instances, they're sent to the government industrial school. The system that we have now is one where we're incarcerating our young people, and these young people are coming from, just different kinds of trauma. They will experience different traumas in their home environments, and then when we put them in the government industrial school, they're being traumatized all over again in the way that they're treated in the system and by the system. So I think that we have to be more responsible in the way that we treat our young people who are incarcerated for whatever reason. I don't even think that it's necessary that, a lot of the young people who are there are there. Yes, people who are in conflict with the law, at the end of the day, we still have to recognize, we still have to hold them accountable. But we have to do that in ways that are fair and that are proportionate to the seriousness of the offenses. We have to recognize that at the end of the day, although not in the same way or in the same extent as adults would be, it's in society's interest to ensure that many of the young people who are in conflict with the law are rehabilitated and become productive members of society. And the interventions that the government utilizes or that the state utilizes basically should reinforce respect for societal values, encourage the repair of the harm done if this is a youth who's in conflict with the law. And also it must be meaningful to the offender, because we want to make sure that whatever interventions are employed at the end of the day, that they understand, or it helps them to understand the error of their ways, to be able to guide them so that they don't repeat or continue to engage in the maladaptive behaviors. I think it's, at this stage, what is taking place in Barbados, it is a situation where, well, right now it is at the forefront, of everybody's mind because of what has transpired in the last few weeks or in recent weeks, or even what happened last year as it relates to the incident where the young lady was reported to have been held in a cell in solitary confinement where she was naked on the floor. Now, these are things that have obtained for a very long time, for as long as, I guess, the institution was in operation. So now I think that the time is right for us to be able to just address these issues once and for all, so that this investigation that the minister recently announced that is taking place, that once this investigation is completed, that we are able to come up with very robust rules and laws that govern our juvenile justice system, help us to be able to change the way that we deal with our youth who come into contact with the court system. We should be able to employ more restorative justice mechanisms and try to help our young people just to become the best that they can be. And by incarcerating them is not necessarily the way to do that. We have to be able to provide family counseling for the family as well, because again, when these young people come into contact with the law, they just didn't wake up being maladaptive. There are things that would have happened in the system, things that would have happened in the family. So we have to be able to approach it from a systemic level, because if we keep focusing on the individual, then we're going to continue to have more of what is taking place now. So we have to be able to look at it in a greater context. Yeah, so for me, that is basically my submission. I think that at this stage, we need to, not just in Barbados, but throughout the region, that we have to be able to move away from the current juvenile justice system that we have, one which does not work. It basically ends up criminalizing our young people more than they need to be. We need to have a greater focus on family. We need to have a greater focus on community and just education altogether of our young people. And that's the end of my submission.
Thank you, Lisanne, for that presentation. We are hearing similar things to what Alexis mentioned with regard to the criminalization of poor children and with ongoing laws rooted in colonialism.
Because you see, the thing about it is that, because the government school in Barbados, that was established in 1883. So we're talking about laws that would have been created for the end of slavery or around that period. And when they talk about wandering, one of the things is that basically was about people walking away from the plantation and things like that at the time. So these are laws that traveled through time and they're still with us, so that people don't necessarily, because I say these are slave laws, because that's what they are, right? And in 2022, even though the Reformatory and Industrial Schools Act was amended in 1998, which is just a few years ago, we still got the slave laws on the book.
Wow.
Whoever the legislators were, they did not see it fit to change the laws that are used to criminalize our young people. Because there's something there about a daughter of a father who has been convicted of an offense under Section 405 of the Sexual Offences Act. So if you're a daughter of a father who has been imprisoned, that is the basis on which a court can say, you know what, we can send you to the government industrial school. Being a girl living in circumstances calculated to cause, encourage, or favor her seduction or prostitution. So now in this case, we're criminalizing or penalizing the victim.
Definitely, and we need to dig deeper at these underlying issues and address those issues at the root, and rehabilitation in a way that caters to children and their needs are important. Thank you for that presentation, Lisanne. Next, we have Ms. Michelle Russell. The floor is yours.
Hi, good evening, everyone. So I want to approach it from a slightly different angle. And I do agree very much with the sentiments that have been expressed by Alexis and by Lisanne. But I first want to say how I even got involved in any of this, because certainly if you hear my bio, I kind of am a misfit, right? Because I do employment law. That's mainly where my focus is, where my passion is, etc. But what happened was, back in around 2017, I was contacted by the family of one of the wards of the girls' industrial school. And the fact that the parents of a child within the institution felt that they needed to retain an attorney almost tells you everything you need to know. And they reached out to me because they were having difficulty getting information about their child. They were having difficulty getting the school to take the calls, getting the school to meet with them and finding out what exactly was happening with their child. And I think I start there because I say that is where the problem with the system begins. Because if you are a parent of a minor child, your wishes matter. Your desire to know of the well-being of your child, that matters. And any institution that believes it can supersede the powers of a parent when there is no legislative framework that gives that exact power, any such institution is problematic and could only emanate from a system that says, I am superior to you. The same system we see in labor, where essentially we came out of slavery and we just switched roles. So we became master and we switched slavery for classism. So that we see, like this was one of the hardest things for me to do because it was a difficult case. I worked on it for close to 2 years. We had several meetings and there were promises made and they still violated them. And in my mind, still violated what are parental rights. And they hide behind this I don't want to say belief, but what they put forward is that once a child becomes a ward at the school, that they then become the guardian of the child. However, I found no legislation that even remotely suggests that as the guardian, they now have superior rights to that of the parent. But I think the confusion comes here. Under the Reformatory and Industrial Schools Act, they do talk about the classes of children or the situations in which children can be sent to the reform school. And one of them is if you're an orphan, or if, as Lisanne said, your parents are imprisoned. So that there is a special section that deals with, and I think it's section 6, that deals with children who are in need of protection. So that in those cases, the children who are orphans, the children who have parents who are imprisoned, naturally, they don't have a parent or guardian that can make decisions for them. So in a case like that, the definition for guardian under the Juvenile Offenders Act does include a school or institution. So in a case where there's an absent parent, either by death or imprisonment, naturally, the school would step in the place of the guardian because they fall within the definition of guardian under the Juvenile Offenders Act. But it doesn't stand to reason that where a child is parented and has an active parent, a parent who wants to be involved, who wants to make decisions for the child, that somehow the school also has the same powers in that situation. The legislation gives no such power. There is no section that explicitly says it, no section that impliedly says it. It's a practice that developed over the years that unfortunately has not been challenged. And I do believe a court would have to rule on it for any system to change, or the minister would have to exercise his extremely wide powers under the Reformatory School Act and change the way they do that. That power rests with the minister. We really shouldn't have to be filing any court action because the minister is the one empowered to make the rules, make the regulations, to establish the school, and to essentially protect these children, right? Now, one of the problems I find, because we can have this forum and we can talk all we want, right? But this is a hard topic, it's an uncomfortable topic for many, and it's easier to stay home in our nice, comfortable homes with little picnic them, and where everything is fine for us and those around us don't have any major problems, than to actually face this. Because I remember when we had the brass tacks episode a couple of weeks ago, and we had a few wards from the school calling in and giving accounts, and one of them like tear me up, you know, like everything in me just a wrap up, so I was dying. And she essentially said she was sent to the school for wandering, but she was wandering because she was being abused for several years by a relative. The relative then got charged and was put on probation, but she got sent up for 3 years. And that hurt me because I said to myself, but this is unjust. This is unjust. We have a system that is more lenient to an offender than to the victim. But we need public outcry, and we need public outcry to be continuous. But what happens is we all get enraged when something comes to the fore, and we call brass tacks and we write articles and we have these discussions and we say something needs to be done. But then it gets a little too uncomfortable and we don't like sadness too much and we don't want the heaviness and we just come out of the pandemic and all of these things are happening. So it's so much easier to hope someone else will do it. So much easier to hope the Marsha Hines and the Alexis Goffs and whoever will do it. And what happens is, as the outcry goes down, so does the action. And we as the public have to be the voice for these children. We have to be the voice for the parents of these children because the system is failing them. And that is where I want to go with it. Why are we treating our children harsher than we treat adults? And I say this in the context of a comparative of the laws. No, the child laws in Barbados are generally under the Reformatory and Industrial Schools Act, the Juvenile Offenders Act. There's the Prevention of Cruelty to Children's Act, you have the Minors Act, the Young Persons Act, and one and two more, right? Then we have the Penal System Reform Act, and this becomes important. The Penal System Reform Act came out in 1998, and this is important. Let me tell you why. As Lisanne rightfully said, our juvenile offenders and reform school acts are old. These are back from the 1920s and 1930s, with the last updates being in 1998. 1998. So since then, they haven't updated the law. There's talk of it, but it hasn't happened yet. But yet in 1998, the Penal System Reform Act came out, and the purpose of the act was to make justice more rehabilitative than punitive, but for adults, which is where the joke about this whole thing is. It actually says one of the purposes of the Penal System Reform Act is to lay down certain principles to be followed by courts when exercising their powers of sentencing. So the aim was to focus on not sentencing or incarcerating adults unnecessarily. So we were able to look at how we were treating the adults in the penal system, but we made no provisions for our children. Now, this becomes important because, as Alexis Goff said, we have similar legislation wording for young persons versus child. The child is under 14, the young person is between 14 and 16. These are the developmental stages where you're still figuring it out. You're trying to find your identity. You're trying to fit in. You're trying to figure out what society or your parents or religion that's teaching you, what of it you want to take. You are short-sighted. You don't fully appreciate cause and effect and the extent of consequences because you're young. Your brain is still developing. You're still absorbing information. And you're going to make mistakes as part of the developmental process. Adults, however, should have more developed minds, certainly have more knowledge and experience and time on the earth, and certainly appreciate cause and effect and consequence more. Yet the law provides more lenient treatment to adults than to children in Barbados. And let me show you how. So for instance, under the Penal System Reform Act, which very specifically says the aim is to focus on the rehabilitation and to make sure that sentencing takes into account the circumstances surrounding the commission of the offense, and to make sure that it's commensurate with the seriousness of the offense, right? Now, under the Penal System Reform Act, the court can make a conditional discharge order, which means the person was found guilty of the offense, a relatively minor offense, like wandering is, but wandering is not under the Penal System Reform Act. I'm just making a comparative between minor offenses. And the court can make a conditional discharge order, which says you are guilty, but I'm going to discharge you on the condition that you don't commit an offense within the next year, or such other conditions as the court sees fit. And then the very legislation goes on to say that this power of conditional discharge doesn't apply to those covered by the Juvenile Offenders Act. So imagine the child who acts out, who wanders, who begs, who does sexual exploration, and is brought before the court. The court doesn't have that same power of conditional discharge. But if the court is minded to send them to the reform school, the legislation literally says it must be for no less than 3 years. So if the focus is supposed to be in the justice system on rehabilitation, why have we not amended the Reform School Act and the Juvenile Offenders Act to focus on rehabilitation? Because the child might be rehabilitated in 6 months. Why is there this magic number of no less than 3 years? So that the child who becomes reformed in 6 months, in a year, in 2 months, is stuck in a broken system for 3 years simply because the legislation says so. But an adult who understands cause and effect can get a conditional discharge. Under the Penal System Reform Act, you can get a curfew order, a community service order, attendance sentence orders, and so much discretion. But yet these things aren't so easily applied to the Reform School and the Juvenile Offenders Act. And you have to ask yourself, why aren't adults being held to a higher standard than what we're holding our children to? When you go down further in the Penal System Act, it very clearly sets out a list of considerations a court should take into account when sentencing. And it says the aim is rehabilitation and to make sure the punishment is commensurate with the offense. Now we need similar wording in the amended, updated version of whatever is going to come out of the Juvenile Offenders Act. Because when a magistrate is given wide powers under the Juvenile Offenders Act in respect of the sentencing, the question we have to ask is, why do they keep resorting to committing the child to the reform school? Because under Section 16, it says where the young person or the child is found guilty of an offense, the magistrate can reprimand and discharge the child. It can discharge the child on a bond. It can commit the offender to the care of a relative or other fit person. And let me tell you why this is important. One of the main reasons that the girls are sent up to the girls' industrial school, government industrial school, is for the section that says where the child is found wandering and not having any home or settled place of abode. And it's not exclusive. You must be wandering and don't have nowhere proper to live. It's not just found wandering. And I wonder how often the magistrates take into account the and. What it says, or if it's not that you're found wandering and not having a proper home, or you don't have proper guardianship, or you don't have visible means of subsistence. There's a lot of those girls who are sent up, they have a home and they have visible means of subsistence and they're still sent up for wandering. And then this whole or proper guardianship, by whose standard? Who judges this? And how does a magistrate judge it? Does the magistrate send for a probation report? On what basis does the magistrate determine whether or not the child has proper guardianship? And even if the magistrate determines the child does not have proper guardianship, why not exercise the power under 16D of the Juvenile Offenders Act, which says commit the child to the care of a relative or other fit person. But they always just jump to E of they send the offender to reformatory and industrial school. And I shouldn't say always, it's often. They can order the child to pay a fine, order the parent to pay a fine, order the parent to give security for good behavior. In other words, there are options. But we end up sentencing this child to 3 years of what is essentially imprisonment, because there's some magic number in 3 years. But an adult who is found guilty in the justice system can get a conditional discharge. And this is the last point I want to make. Under most of our criminal legislation, and I'm no criminal attorney, but I certainly checked most of them, the sentencing is within the discretion of the magistrate. At the very least, the legislation will say imprisonment of 7 years, imprisonment of 14 years. So it gives the magistrate a discretion between, it gives you a maximum, but it don't give you a minimum. It's very rare you see the minimum. So like for murder, manslaughter, conspiracy to kill is life imprisonment. There's no discretion with the magistrate. So the adults get this discretion of only a maximum, but not a minimum, so that the magistrate can say 6 months. The magistrate can say a year. But when it's a child, the discretion is taken away from the magistrate who chooses to commit a child to reform school, and the child has to be there for no less than 3 years. So our system is being kinder to adults who fully appreciate their actions and consequences, and in short, should know better and do better. And it's being much harsher to our children in their developmental and crucial stages. And I think that's the conversation we need to have. That's all I'll say for now.
Thank you, Michelle, for that very passionate presentation, and for those firsthand accounts of what is happening on the ground in Barbados. It is true that it is an uncomfortable conversation for some, and it is a conversation that I think needs to be had. Thank you for that call to action for us to advocate for the children in our society. I want to open the floor for questions. Feel free to place your questions in the comment section in the live stream on both YouTube and Facebook, and we will answer. We will try to pose those questions for you and have the panelists answer them. I want to pick up on something you mentioned, Michelle, in terms of parental rights. Can parental rights be terminated if a child is incarcerated? And I think you mentioned that. Do parents have a say in things like healthcare and such, like cavity searches, medical procedures, medications, etc.? And I want to hear about both Barbados and Jamaica. How are your parental rights? Do you have any? What parental rights do you still have when your child is incarcerated? And any of you can jump in here.
Well, it's like I said earlier, the practice of the school is to usurp the rights of the parent. I still cannot find any legislative backing for that, except in the case of orphans and children who might have parents in prison, because that was the original plan for it. I do not know on whose authority they have widened the scope, but it's not been challenged, because let me tell you, working those 2 years, I mean, we had as simple as they were medicating my client without the parents' knowledge or consent. And one of the things we objected to is that they didn't even know the child's medical history. From the time she was admitted, she was medicated. She was medicated and she was young. How do you not consult the parent? And then they promised, she eventually came off and they promised us they would not medicate her again without our knowledge or consent. And then we found out she was back on medication and they dug their heels in, saying, oh, they're the guardians and they can. But who's liable? Because let me tell you something, if something happened to that child and she had an adverse reaction because of course they had not checked medical history or sought consent, the liability would naturally fall to the school and they would try to find every excuse why they should not be liable. And this is unjust. And that's why I it has to be challenged because the minister has powers under Section 53 of the Reform School. He's the one who gets to decide what the rules and regulations are. He gets to revoke them. We should not have to go to the court for a declaration as to whether or not the school has superior rights to that of the parent. The minister can step in. He can fix it. Or Parliament can update the law to make it clear, but no one wants to talk about these things because once those girls are up there, they're deviants. Didn't you see what the chairman of the advisory board referred to them as just deviants? And when you have troubled people together in the same location, this is what they'll do. They'll make trouble. As if the only possible explanation for them acting out is that they're deviant and troubled. Even deviant and troubled people can have justified reasons for their behavior. And when we have an advisory board that takes this kind of attitude, you have to worry. Who is protecting the girls? And that's why I say we as the public have to be the ones to do it. And I'm going to shut up because I'll go on forever.
Lisanne and Alexis, do you want to add?
The whole issue of the 3 years, the 3 year minimum, Michelle, now that we're having the conversation, it makes one question the constitutionality of this, because basically they've taken away the discretion of the court, to determine what is a reasonable sentence or what is proportionate for whatever the offense is that the child is charged with, if it is a child who is in conflict with the law, right? So they've taken away basically the discretion of the court. So then one has to question whether this is really constitutional or how constitutional is this?
Thank you for that, Lisanne. Alexis, are you with us?
Yes. So in Jamaica, once a child is incarcerated or institutionalized, parents are hardly kept abreast of what is happening and what goes on in the institution. To go further, there is even a lot of barriers for parents and families to maintain contact with their children who are institutionalized and incarceration. The visiting policy is really is inhumane. Really, it is not meant to maintain relationships and attachments between families, friends, and the child who is incarcerated. And also the location of our institutions makes it incredibly hard. All of our institutions, our prisons, child prisons are in Kingston, Jamaica, and Kingston and St. Catherine. So the eastern side of Jamaica, southeast side of Jamaica. And so children who are in, Westmoreland or Montego Bay or whatever, like their families would have to travel an extreme amount and of course, foot the bill and all these things in order to get there to visit the child. And child visitation can actually be anywhere between 15 minutes. If you're lucky, it can be half an hour. So it is inhumane, right? And there isn't a maintenance or an effort to maintain efforts between the families and the child. Now, what's important, and just to what Michelle said about the chair of the advisory board saying about deviant, like the state and public officials use these terms and these narratives so that they can deflect responsibility, so that they can dehumanize the children and their families, and to make it seem to the public that like this is nothing to worry about because the families are lazy, the families are bad, the children are wild and going crazy. So nothing humane here. There is no human here. There are no feelings here. And this is again very much from our colonial past. And that's why one of the things we have to do is challenge that. One of the things they say in Jamaica is, but the family don't even come anyway. Don't make sense that we try and help them to come because the family don't want to maintain contact with the child. And so there then is no effort made because we have now dehumanized and stigmatized the family. There's no effort made by the institution and by the staff to maintain that contact. So very, very, very harmful things can take place to children without their families knowing. There is serious over-medication and reliance on medication, especially in the absence of programming and activities and structured programming and activities in institutions. And they rely heavily in Jamaica on psychotic medication, even if the child has had no diagnosis of a mental health challenge, right? And even if they have, 9 times out of 10, it is not a diagnosis that warrants such strong medication that is again just meant to suppress and make sleep and sleep. I organize with survivors, and one of the things that they've said is when something happens, they're very glad, or they're afraid to take their meds at night, because if something were to happen in the night, they would not be able to wake up, right? When there have been fires and I've been right there immediate as a first responder on the ground and talking with children who were in that institution that had a fire, they have in chorus said that thank God I never took the medication that them gave me, because if I had taken it, I don't know if I would have had the presence of mind to leave when I needed to leave, to react the way I needed to react. And so the last thing I'll say about this is, a lot of this is in contravention to the policies of the state. And so we have to as well go further than fighting for the policies and the legislation, because the state routinely breaks its own policies. And then what do we do there? And that is what happened. That's where we are at in Jamaica, because we fought for the Child Care and Protection Act. It came in with bells and whistles and people were super happy. There was a bit more of a formal structuring of institutions, child institutions, not really child prisons. But that hasn't changed the material conditions and the challenges that children face from state violence, because the state just will routinely break its own policies, break its own laws. And so that is why also we have to go fight beyond the legislation and keep at it, because we slept after the Child Care and Protection Act. And we thought things were fine because we have this act. And we have repeatedly had every single year major reports of abuse of Jamaican children in institutions that goes against what is even law. And so we have to stay in the fight, really.
And it's unfortunate. Thank you. And it's unfortunate that we are hearing reports of abuse in spaces where children are put there for their protection, and the children are being violated in these spaces. That is very horrendous. I want to ask a question about incarceration. When a parent with a child who may have behavioral issues and they're not accepting what we term parental guidance, and they're considered out of control or deviant, another word is often used, which are used to describe children who may just need some extra care and attention. What happens when a parent takes that road? What is the procedure like when parents seek out state assistance for that child? Tell me about, I know you spoke a little bit about the sentencing and what happens and the lengthy sentences. Can you tell me a bit about what happens when a parent seeks help? Because some parents have spoken out, they needed help with their child and they sought state help, and then they regretted doing that. So what is the procedure like in both Jamaica and Barbados with regard to when a parent seeks help via the state? What is the procedure? What happens to that child? What happens?
Generally, or in many instances, this is where the child will end up going before the magistrate. And it is at that point where the child will more than likely, in a lot of instances, be sent to the government industrial school, right? And one of the things that I think are, in my mind, I'm thinking that we need to have child advocates in our system, because that's something that we don't have. So that when a child goes before the court, there is nobody there to advocate for that child. And I think that one of the things that we need to have in our system is child advocates. And an advocate that not only goes to court with this child, but they're able to interact with that child, if it is that they are sent to the government industrial school, that this is a person that this child now can interact with, you know, that they can be there to be more or less, let's call it a watchdog, more or less, to make sure that this child's rights are not being violated whilst it's in the institution, right? Because at this particular point in time, when a child goes before the court, they don't necessarily have anybody to advocate for them.
Anyone else wants to go? We have a comment from YouTube. Susan is saying that this is another part of the issue, conditions in which children are kept, how they're treated once they've been incarcerated. So neither the laws nor the conditions are in the best interest of our children.
So what I'll say about that and tie it into the question that you asked is that best interest, who perceives what is in the best interest of the child. And so there are a lot, I mean, like I've interacted with a lot of probation officers, for example, not even probation, but a lot of teachers, for example, or police officers who think that bringing a child into this institution is good, right? Or who think like spending a few nights in a police cell, in a police lockup is good for the child, right? And so I just want to again just hit home, like we're not all on the same page, and we will never be all on the same page about what that best interest of the child is. And we have routinely seen in Jamaica, the judiciary has shown us, prosecution has shown us, the legislators have shown us, the prison staff has shown us, the police have shown us what they determine or they have interpreted best interest of the child to be. And that is to be in a perpetual state of violence and of harm. And so that thing I said, I think it was Kellyanne, you said like that parents in Barbados are saying like, I wanted support from the state. And this is not what I had in mind. I'm asking folks or suggesting folks, I don't know if you can see it, because I'm all fuzzy, but this is the abandonment of children in Jamaica. Is a report that was done by Erna Bradba, sociologist Erna Bradba. And I suggest people, if you can get it, have to read it, and have a copy, electronic copy if people want. And this was done in the 60s in Jamaica in relation to or in response to numerous reports or increasing news reports of children being abandoned in various places, fire station, in front of a church, at a police station. And so there was widespread reaction about the increase of children being abandoned. And so Dr. Bradba was commissioned to do this report on behalf of UA. And one of the things that Dr. Bradba said, up until reading this report, I was saying, how dare these parents take their child to the state because they're having a challenge with their child? How dare they take the child to the police station? They don't know there are other places that they can take the child to the police station. What Dr. Bradba says in here and found in here in her study and in her research is that the police station or parents are going to use, families are going to use what's most available and accessible to them. And if the state has decided that the most accessible thing for parents and for families is a police station, then that is what, or the courts, then that is what they are going to use. And so parents frequently will go in good faith to the state and say, I am struggling, which is a rational, expected experience of families raising children, much less families who are in social and economic conditions that make it increasingly hard to survive and increasingly hard to cover all of the expenses and all of the resources that they need, right, to live well and to be healthy. That is rational. It's a rational response. But that the state's response, right, has then been, well, we suggest institutionalization, right? We suggest incarceration. And so it's not necessarily all on the parent's fault, because yes, the parent comes with the complaint, if you will, right? And Broadband shows from the 60s that the number one reason parents came to the state was for the state's language, beyond control, which for many parents, it wasn't, I'm done with this child. It's just that this child is just not following my, rules, or I'm having a challenge with the child listening. And the state's response has been spend time in the lockup, right? The judiciary's response, or the legislature's response, has been, you can be charged with uncontrollable. You can be rounded up as uncontrollable and sent to prison, or sent to, in a place of confinement. And so this study shifted my framing about where we have to really pinpoint the dynamics that are at play, and that there will always be families that are wanting support for raising children, while they raise children. And that is natural and normal, and that we have to fight, like activists, advocates, families will have to fight to ensure that it is community, I think it was Lisanne said, like community resources, community resources that are support that is provided for families and for children. And not just activities and programs, but last thing I say is also, of course, we have to look at what are the jobs? We have to look at underemployment. We have to look at salary in relation to cost and expenses. We have to look at access to health and access to health care. People will say, send your child to the child guidance clinic in Jamaica if you have a challenge. Child guidance clinic, last week I called child guidance clinic, and I can't get a session for a child that I'm working with, a family I'm working with, until October of this year, right? And even then you're going to be seen maybe once a month, right? And so there is, one, because of austerity measures and neoliberalism and thing, a decrease in the social safety net in Jamaica. And so that is one of the things we have to fight for. That's one of the major things to fight for, is that the resources that are there, that we have available, are for support of families and of children, and not a reliance on detention, incarceration, and institutionalization.
True. I find support and resources are critical. Go ahead, Michelle.
I wanted to say something on that. Earlier, Alexis said, we still follow in some of the systems from our colonial past. And in my head, I was like, no, our colonial present, let's not lie. Because it all comes down to beat them into compliance, My child is not listening, so we're going to beat you into compliance, which is what we did with the slaves, right? You frighten them and put the fear of God, don't know which God, but the fear of God into them, and you beat them into compliance. And when the beating not working, you find harsher and harsher, and that's all you do, harsh. That's what you see in the workplace. The employee had the nerve to talk back. How dare you? Do you know I pay your salary? So I'm going to find a way to beat you in compliance. But in the employment context, you have your warnings and your disciplinary measures and the threat of firing. When we look at human relationships, whether marriages, friendships, it's the same, beat you into compliance. If you don't change, I'm going to leave you. I'm going to cheat on you. It's beat you into compliance. We took that system and we just painted it a different color. And then we put it in every area of our lives. And like Alexis said, even if we change the legislation, the system protects itself. Capitalism protects itself. Socialism is too expensive, and we won't be able to live good lives. At least some of us won't be able to live the good life we're used to, because we're talking about having a child advocate at the court who going to do it for free, where you could be billing $500 an hour, sit down free for help somebody you never meet in your lifetime. Yeah, go poor. What's the point of studying for 5 years to do law and doing free work? When you're saying people calling and trying to get an appointment and you don't have nothing available till October, you may have other therapists and stuff saying, well, my calendar is full. And the reality is we have to be real. We have to pay with bills. We can't help. I always say I can't do activism if I'm not able to meet my bills, because I'll be so worried out the road I beg food that I don't have the time and resources to be committing to it. So you need both. But a lot of people are not willing to take a little less in earnings to then give up their time and their resources, because of course classism replaced the house slave and the field slave. So now we have to show how much we have, and to have enough, we have to work extra hours and in certain fields only and doing only certain things. And the appeal is just not there. But yes, it's just colonialism by another name. We beat them into compliance.
Wow. I have a question from Karen. Would a child advocate help, and has this been done, and has it helped?
Well, I think a child advocate would help to the extent that when a child goes before the court, like now, let's say they don't have an attorney, the magistrate can pose certain questions to the child. They can ask, the parent certain questions, but generally they're not educated to a certain level where they're able to efficiently advocate for themselves. So it would help if they had somebody who knows, the system, and who has certain understanding of things to be able to advocate for them. Like I worked in another jurisdiction where child advocates was one of the things that a child who comes into contact with the system would never go to court without. They would always have an advocate, right? Because at the end of the day, there has to be somebody there to represent that child's interest. And I think that that's one of the things that we need in our system, but exactly how we would go about it, because at the end of the day, if it is something that's funded by the government, then we're going to end up in a situation where we've got the same beast that we're fighting against is who we gotta be working with or trying to get to protect our children. So how do we go about it? Unless there are NGOs out there who are prepared to provide that kind of service, it poses a challenge.
Thank you. We have another question. Well, it's a bit of questions. Angela is asking, is there legislative provision for cavity searches? Are they really done? Angela has heard of cavity searches. Should they go to churches, social workers, guidance counselors, other family members? Is that what you're thinking, Mr. Goff? Now that we know, or it is suggested that the system is broken, are you hoping that the new legislation, which is to come to Parliament, having specific things? And if so, what changes would you like to see councils?
All right, I'll just address probably two of those. There's nothing in the Reformatory Schools Act that even mentions cavity searches. There is an indirect reference to a medical examination. Mm-hmm. I think that's more under the Juvenile Offenders Act than the Reform one. Sometimes mix up the two. Even if, and I scoured all the legislation and I couldn't find anything that gave the police power to determine that they want to do a cavity search outside of reasonable suspicion of something that cannot be found out but for a cavity search. But what I can tell you from my personal experience with dealing with my child is that they justify it, or they claim the reason for it is to check to see if the child was sexually active. But that's not an offense. It is not a criminal offense for an underage child to have sex. The offense is committed by someone who is over the age of 18, who has a child with a minor. So that there's still no justification. Normally, with most searches of the person, there has to be a reasonable suspicion of commission of some offense, right? Somewhere, somehow. And it can't be just we checking if the girl had sex. And even if it's a practice of the school, I continue to say the minister has power to revoke that. And the failure to confront it and to hide behind pretty language and deflecting of responsibility is disappointing. Because as women, we know when we consensually got to the gynecologist, I have to cock up with 2 foot with consent. It is a very uncomfortable experience.
Mm-hmm.
So imagine what we are doing to our girls who are not consenting, and we are forcing them to do it. Now, the police don't do it, and the school don't do it. It's the medical doctors that they hire that do it. But on what basis? Except an archaic practice that should be thrown away. Are we examining the genitals of the boys? You understand? So it's like, it's bad. Girls having sex is bad, and they must be subjected to shame and dehumanization. Boys having sex is, come on. We're past that. We have whole apps where people go on the app just for sex. We are long past that. The other question was what again? Which had like 5. I knew they wanted to
searches. Should they go to churches or social workers, guidance?
I leave that one for Alexis and for Lisanne. But the question of what changes.
And then there's another one on the new legislation. What are some of the specific things?
They need to just get rid of it to tell the truth.
Changes that are needed.
No, man, they can't get rid of the legislation. Most of it is not, it doesn't help. What they need is an actual reform school where there's education, there's actual instruction. Right now, the children are not educated. They either self-educate or then just pass the time. So it needs to be changed completely where there's not the punitive element. And funny enough, under the Convention of the Rights of the Child, they do make a distinction between children who are committed to these reform schools for having committed an actual offense, like a violent offense, versus those who are there because they're in need of protection. And you're supposed to separate them, there's supposed to be a delineation. They're not supposed to be in the same section of the school, not supposed to have the same treatment. And as far as I'm aware, we have no such delineation at our current school. So those are the kind of things the legislation needs to address. I remove everything else that no longer, them still are talking about whipping. It literally, the legislation speaks of whipping, They say the girls shall not be whipped, but the boys shall be whipped. And then it says the maximum number of whips.
24 strikes. 24 strikes.
Come on. So most of it to me can be done away with. Most of it. And if they insist on keeping a reform school, it needs to actually be an educational institution, which perhaps will just be fairly regimented so that the kids learn routine, but they must have an on-site counselor, on-site social work, qualified people, not people who just have to watch the kids, so that the real purpose is reform and everything else just throw it in the garbage. But they say I'm too harsh with these things.
Because currently there is no, because they call it a reform school, but there's no synergy between the school and the Ministry of Education. There is none. And I'm thinking, because if they're saying that the government industrial school is not a prison, then why is it basically governed by the Ministry of Home Affairs, which is the ministry that governs the prison? Why could it not be governed by the Ministry of Education?
Now you mentioned education. On the topic of education, whether it be academic, technical, vocational, issues have been raised recently in the media and in research about children who are in state care and not having access to proper education, which infringes on their rights and further adds to their vulnerabilities after they leave these institutions. I know generally parents can be charged for not sending their children to school in normal circumstances. Does this apply to the state? What does the law say about children of certain ages being enrolled in school and having access to an education? And does it apply to children in the state?
That's the thing, because a parent can be brought before the courts for not sending their child to school. Mm-hmm. However, and this is between the age of 5 and 16. Mm-hmm. However, the school can expel a child who is younger than 16. So even though the law says that if you're between the age of 5 and 16, you're supposed to be in school, if you go to school and you misbehave, they have the authority to expel you. So they have the authority to contravene the law, which says that if I'm between the age of 5 and 16, I'm supposed to be in school.
And are there any stipulations when a child is expelled that they be placed in another institution to be able to have access to learning? And what about at the industrial schools? Don't those laws apply that children must have access to a proper education?
Well, they don't necessarily apply in the sense, well, according to what they do, they say that they provide some kind of education. The question is what kind? But as it relates to children who are expelled, yes, if there's another school that's willing to take the child, then they can go to school in that regard. But the school still has the authority to expel a child if they feel that the child is not conforming to the rules.
Okay. Anyone else wants to add anything here? Okay, I have a follow-up question. Should the child advocate's role be built into the new legislation?
I personally think it should be, but again, the question is, who is this advocate going to be? Because if the advocate is somebody who's working for the government, yeah, I think we're still going to have some problems, because at the end of the day, there's this thing called groupthink. And after a while, they're going to get into a particular culture. And then, some people, in my mind, there are lots of social workers, because I worked in the government system for a while. And there are people who come in with the best of intentions. They want to make change. They want to be all the change agents in the world. But then when they get into the establishment, then they realize, you know what, there's a lot of resistance. Because if you come in and you want to be a change agent, and then the people in the establishment, they're operating and doing something else, then it creates a problem for you. And so a lot of people will, you know what, if I want to survive in this system, this is my livelihood, this is how, I put food on my table, it means that I'm going to have to go with the flow. So now I'm going to fall into the group thing. So I'm going to become like everybody else. So the challenge is, who would be the advocates? Because for me, it would have to be that we've got NGOs or entities that are separate from the government who are able to provide that resource. Because if we're relying on government employees to provide the resource, then we're still back at square one.
What the legislation could do, though, the legislation could make it mandatory that an unrepresented child cannot be committed to the school. And the legislation can expand, the legal aid legislation, Community Services Act, I think it's called, that could be expanded to include representation in these kind of matters, because you can't get legal aid for everything. But it can be also amended to include, so that you might find more attorneys willing to do it, because it will fall on the legal aid and there'll be some payment. But as a labor attorney, I can tell you, your fidelity is to who pays you. You cannot have child advocates being part of the government system. It will put them in a bind. So it needs to be completely independent, and we can get community legal services to expand to provide payment for this kind of legal service. And the act can say, can't send them up without representation first.
I have a comment from Jerry. He says, I am not too familiar with the procedure in Jamaica, but in Belize, whenever an incident would arise with a child, our Human Development Ministry, also known as Social Services, would get custody via the court system for 3 months, or would otherwise use a family member to keep the child or children for such a period. He's not too certain if you, the panelists, would have the same process. And I think he's specifically asking about Jamaica.
The common process in Jamaica sounds similar to Barbados, in that institutionalization is frequently or commonly used. We do have foster families as well, and there are quite a number of children that are in foster families. The way we frame foster families in Jamaica is kind of, to me, is a bit weird, as if it's kind of saviorish and it's like all great and thing. There are challenges. One of the most under-researched and most invisible groups of children are children in foster families. When I was in Minnesota, there's a lot of things that was uncovered about treatment of children in foster families. In Jamaica, historically, some foster families have wanted foster children for housework, right? Like there is an intersection of labor and child labor and having foster children. And so, you know, the Jamaica, I would say, common would be, you know, even the thought, the premise is that they don't want to go to institutionalization, but we still have a lot of children on institutionalized, and sounds like similar to Barbados. No matter what age that child comes in, your fit person order was going to be until you're 18. And there is foster family or a foster system as well that children also go to. So we don't, it doesn't sound similar to what you described in Belize. Yeah.
Okay. You mentioned having some persons get foster children for housework. As awful as that may sound, I don't think it's surprising. I want to ask about child labor under the law. Generally and within these institutions, recent research revealed that in Jamaica and some of our other Caribbean islands, children who were under the guardianship of the state were often indentured and rented out for labor. In the Barbados legislation, from my very limited legal knowledge, I also came across bits that speak to indenture and apprenticeship, where children can be licensed to live with a trustworthy person, or they can be sent on apprenticeships to serve sea service or service in another Commonwealth island. Can you share with me your insights on that practice and how that translates into our societies today? Learning skills or having training and internships is different to indentureship. Can you share your thoughts on that in Barbados and Jamaica across the Caribbean, based on your collective expertise? Anyone can go ahead.
I don't think it's used anymore. I don't have knowledge of it. It probably was back in the 1920s.
Okay. Next question. Want to ask about protection of children, confidentiality versus speaking out. In your experience as a therapist, Alexis, and your legal expertise, Michelle and Lisanne, what is the difference between confidentiality and speaking out, and laying bare the issues and situations of abuse that many children experience, some of whom are institutionalized? In our societies, we know that when it comes to abuse, especially sexual abuse, it is often kept silent. Some may say speaking out makes it harder for the victim. Others may say it prevents it from happening to others, as the silence is broken and the perpetrators can no longer hide. You often hear girls are picked up for wandering because they're running away from abusive situations. Can you share your insights on confidentiality and protection of children versus speaking out and bringing awareness to these types of injustices experienced by children?
Confidentiality is a shield and a sword. Depending on the context in which it is used, it can be either. So it can be good and it can be bad. The irony of it is that the legislation does very specifically say under the Juvenile Offenders Act, they're not supposed to release any information about the wards, right? And we would recall that last year when there was a leak of the story of the young lady naked in cell in solitary confinement, there was a big hullabaloo about this was breach of confidentiality, and the member of the board who released it, who I still consider a modern day hero, but the member of the board who released the information had breached her duty of confidentiality as a board member, because that falls under company law, right? It's not untrue. But if you try to work within the system and the red tape within the system that is put there to protect the system will continue to protect itself and harm those it's harming. So in that case, confidentiality was being used as a shield. But then the same people turned around recently when the girls escaped and put all the information in the media, all in clear breach of the section within the act. So confidentiality is a shield and a sword. I think that I think that sometimes the problem is that it's going to come at great personal risk. And I think some people don't understand the risk Dr. Himes took when she blew the whistle, because there was no whistleblowing legislation to protect her. And she lost a lot as a result of it, but she saved a lot. And so if you decide to breach confidentiality, and depending on in what medium, because directors have a certain kind of fiduciary duty, which is like of utmost good faith and all of that, there will be consequences. And so you're really going to have to decide, weigh the balance of convenience and the balance of justice, if it were. And but I think most often confidentiality is used as a shield by the system to protect itself. And sometimes you might have to examine whether or not you want to do something else.
Laurel is asking any suggestions from the panel regarding how Caribbean jurisdictions can utilize a more decolonized approach to juvenile justice.
I think one of the things that we're going to have to do first is a lot of brain scrubbing, because we are so entrenched in the way that we deal with children and how we perceive children should be dealt with, right? That people's minds will have to be totally reformed in order for us to have an effective system, a system that actually works. Because up to now, you know, people don't necessarily see them as, I don't want to say human, but they're little humans, and the things that affect us, like there are things that we can do to them and get away with, and we don't think it affects them the same way that it would affect us as adults. So I think that people first, we will have to reform people's minds, restructure their minds and how they perceive children and how they deal with children and how they think we should deal with children. And then I think that we would have more or a better result when we try to implement changes.
Yeah, I would add on to that and say, I think what we determine is the next step is greatly impacted by the angle at which we look at things and the lens through which we look at things. And it took me a very long time to realize that it isn't a broken system. It sounds crazy to think that these harms that are taking place and the perpetual violence to children that takes place in these institutions and by the legal framework is like, is the purpose of it. But what other interpretation can I have when in my limited years of following child rights in Jamaica and seeing the developments of people going to the UN in the 70s and making the similar reports to the UN about state violence against children in children's homes and prisons, right? And promises made by government and still no material improvement done. And what do I say about the 90s, where we had two major reports that were released about the hundreds and thousands of children in Jamaica that were kept in police lockups, right, with adults, right, limited ventilation, limited light, meals being withdrawn. Front page of the Gleaner, which is our major, newspaper. And again, promises and press conference and no material improvement for children. What am I supposed to say in the early 2000s, when the Privy Council ruled that it was unconstitutional to lock up children under Governor General's pleasure, which is really indefinite detention, right? And that we still have in Jamaica prisons adults who were locked up as children in the 70s and the 80s, who are still in prison despite the Privy Council ruling and have not been released. What am I supposed to think about Armadale, the prison for girls, that a police officer, because children actively tried to plan their escape and their liberation because they were kept in a cell that was supposed to have maximum of 5 people and had 23 girls in there. And they were protesting the conditions that they were in because they were on lockdown for 23 hours every single day, right? And when the prison staff called the police to come, the police came and used tear gas and threw the tear gas canister into the cell, which caused a fire which murdered 7 of the children. 2009, and we're 13 years later, and nothing has materially changed. In 2020, a report that was from the Rio Cobre Boys Prison in St. Catherine in Jamaica about children who were kept in solitary confinement for days and several weeks, withheld food, stripped down to their underwear, right? That a child who was epileptic had seizures while in solitary confinement and could not be reached, could not get immediate attention because the friggin' person who had the key could not be found, right? What am I supposed to think this last year when another report has come out, right, about inhumane treatment of children in prisons, and it hasn't materially changed anything? Is that this is the intention of the system. This is the intention of the laws, of the legislature. They are honoring the planter class, they're honoring their colonial ancestors by maintaining these laws that target children from Black, poor, and working class families. And so if we have no other analysis, if we think that it is a mistake or a mishap and we just need to highlight it so that something will change, we will perpetually be in a cycle of outrage, some task force, maybe some legislative promises or something, and we're going right back into silence. Outrage, some task force, and we're going back into silence. And we think that it is a mistake. It's not. It sounds cynical. It's not cynical. It is an analysis. This is the system working as intended. And so we have to, if we're serious about that and the liberation and ending that, we have to include that in our analysis and look at anything that will limit, will drastically reduce the number of children that are in these institutions that are the perpetual violators of human rights and the perpetual violence perpetuators to children. Cavity search is sexual violence, right? Let's just be very clear. Assault and corporal punishment is physical violence, right? Solitary confinement is torture. And these are embedded practices in the system. And so anything that I'm telling you from Jamaica's standpoint too, with the CCPA Act that was lauded, that the state, anything you fight for, you can't let go. And you have to keep fighting for it because it will go right back to the way it was. And the starting point is to develop an analysis that accepts and understands that this is the colonial capitalist project that says we have to have a group of people that we exploit and we have to have a group of people that we repress, and that is poor working class people and their children. Now, what do we do from there, and what are our demands from there? That's what we need. That has to be the starting point.
Michelle, you wanted to say something?
I just waiting to hear you talk about his impassioned presentation and his impassioned plea, because I know you use the word passion when I was talking, and I said, well, there is brother passion right here, and it's over here. But it's a breath of fresh air. Like
my family in Barbados, to my family in Barbados, it's gonna happen again. We have to group up because it's going to happen again. It sounds cynical. It is not cynical.
It's true.
It's not pessimistic. It is going to happen again. Don't settle for the promises of what is going to happen. Don't adopt any of the talking points and the narratives that seek to dehumanize the children and their families. Do not question it all. Always question it, and do not wait on the politicians to, change, because it is 2022, fam. They've had multiple opportunities to. And so we need to get out of that cycle, group together and organize persistently. That's one of the things we don't have in Jamaica. We have not had a persistent child rights movement anti-criminalization child rights movement in Jamaica. It's the same set of people that do police brutality, that do environmentalism, that do all of these different things. And we need people to decide that this is their lane. They're going to study the heck out of and understand how the system is set up in the respective countries and in the Caribbean, and they're going to follow it like hell, because we need those people to be combating the narrative and to be reminding people, because there is an engineered amnesia that happens, that you forget what happened, that, oh, Ross, this happened. There was a task force 3 years ago, right? And here we are, right? Like, so don't accept the task force again, you know? So it's gonna happen, and to get out of it, we have got to group together and to organize sustainably.
We have another question from Angela. Do the magistrates need greater training and sensitization, and who should undertake this training for them? You think an international children's agency? That is the question from Angela.
I've been a part of nonprofits in Jamaica that have gotten a lot of money to train and to sensitize, especially after the Child Care and Protection Act. And it sounds good on paper. And you might get one or two of the family court judges or that are about that life and like will listen and this kind of stuff, but it hasn't resulted in structural systemic change. As Lisanne said, like, our mentality, there's so much to unlearn and so much for us that we have to like challenge in our minds. That I would say training and sensitization alone, and if you have limited resources, like, that's not going to be enough. They will get funding, but it will not be enough. There have got to be structural changes that we fight for. And if we have limited energy, I would fight for those. I would fight for those. And actually, on the topic of advocates, I would also say, if you can create community defense groups, community child defense groups, do that. There are some in St. Mary, Jamaica that I have witnessed and I've been a part of. There are some in St. James, Jamaica, St. Catherine, which are community groups, groups of people that like they meet regularly, and they're building resources and some funds to ensure that the children and families in their community are protected. And if there comes a time that challenges come up, financial or otherwise, that there's a community response there. And this is outside of the system that already exists. So it would help if we get off of that thought process again of waiting on that state. I love the discussion about the state advocate thing. Is that gonna really work? I agree. And there's stuff that we can do within our spheres of control to build power that is not necessary and dependent on the state. And when actually just 2 months ago, in this specific community, a child was referred to Child Care and Protection Services for, I think it was neglect or something like that, by the guidance counselor. The family the community defense swooped in and said, we got this, we're good, don't bother come, right? Like, we don't take this child. This is a good freaking family. We just need support. And think about how crazy this is. The system is not going to support a family that's having, financial challenges, right? Neglect is a way of criminalizing poverty, right? They're not gonna give that family financial resources. They are not also very hard to get them to do next of kin. They're not gonna give rights to the grandparents, or maybe it's very hard, the uncles or the aunts. It is very hard in Jamaica to get that to happen. What they will do is take the child, give it to a foster family, which ultimately is a stranger to the child, and give the foster family funds. That not sound crazy? Why not we do that initially to the family, to the original biological loving family that is operating within the constraints and the frustrations that they, find themselves in. So we have to, we have to make these demands that are very specific and point out the contradictions that we are operating in.
Does the same apply in Barbados, Michelle and Lisanne, with regard to familial support or giving a child guardianship under a relative as opposed to putting them in foster care? Does that happen? The same thing happen here?
A child, they can or they may be inclined, depending on the family, it depends on the situation as well. As far as foster care is concerned in Barbados, that don't happen too much. Because I remember an officer in the child care board told me, people don't want older children. They prefer to foster babies, but they're not interested in taking older children. So generally, usually you don't find older children being taken into foster care in Barbados.
And our last bit of comments, because we're running out of time and I don't want to keep you any longer from your busy schedules. We have one comment: laws should be reformed to handle the nowadays generations for criminals have adopted new techniques to challenge the justice systems. And if we take a proactive approach instead of a reactive one, there will be a rippling effect in all stakeholders to save our young ones from becoming juvenile offenders. And another issue is reintegration. So to end, I'll ask you, each of you, to give your parting words on our discussion tonight. I want to invite you to make your parting words. Michelle, you can go first if you want.
Man, I just hear thinking I like listening to Alexis. I just want to hear his parting words.
Oh, you don't want any discussion?
I don't know. Sometimes I feel stuck. I think it's sometimes a problem with activism. You're fighting against a system that protects itself, and you're fighting to keep people interested in fighting the system. And it can become exhausting. And I think the more who get involved and share the load makes it more possible that the fight can continue and be effective. And that's perhaps all I'd say.
Thank you, Michelle. Lisanne? Oh, Alexis, go ahead.
I'm just gonna add very quickly to Michelle's point. It's such a good reflection that, like, if we are so tired, we have to ask, are we tired of reacting, right? Are we tired of reacting? Are we tired of feeling like we are the only ones? And that's why I think it's so important that we do connect with people, and that this doesn't only take place in NGO settings and policy settings and that kind of stuff, but that we connect with our people and see of our people who have like minds, who believe that the system has to be challenged on an economic, social basis and transformed, and that we start to meet up, and that we start to share resources, and that we start to make specific demands of the transformation of the conditions that our families and our children are living in. And that if we repeatedly have these spaces and a political home, right, if you will, where we're learning and building an analysis, and think that is going to be such an important factor in changing this and coming out of this cycle. And so I would just say that we have to organize, and we have to be in groups and meet with people, challenge ourselves, unlearn a lot, to combat the feeling of the loneliness, which is so real, and the frustration and burnout. I think it was Audre Lorde that said that despair is a tool of the oppressor, something along those lines. And so we have to fight the feelings of despair by putting in action and not just being constantly sporadically outraged and then back to sleep. So
thank you, Alexis. Lisanne?
Well, I will say that our children, they basically are our future. And like I say, they're vital have a vital role in our nation building. So it's important that we keep the fire, on the authorities and the powers that be, and the people who have the power to create the change that we need, because we need to have our laws amended to come in line with 2022 and with the new millennium. And basically, we need to keep, those people accountable at the end of the day for what is taking place right now. We need to be able to come together, like Alexis has said, and just create those communities that will provide protection for our children, so that it's not left to the state to come in and deal with them, right? Because at the end of the day, they're a reflection of us. Everything that we've taught them, whatever is taking place with them, it is what we have taught them, and they're basically manifesting what we have sown into them. So we're partly responsible for whatever the damage is that is taking place or is going on out there. We are partly responsible because this is what we have exposed them to. So now it's our responsibility to repair the damage. So it means that we have to keep pressing forward, to make sure that people in power and in office do what they're supposed to do in terms of creating the laws and legislation that makes it more amenable to our children.
Thank you, Lisanne. And with the principle of leaving no one behind, one of the UN's universal values for sustainable development aimed at reducing the inequalities and vulnerabilities within our societies that hinder development and prosperity for all, but yet what we have spoken about tonight, our most vulnerable, our children, are being left behind without measures of social protection to give them the full, to allow them to live their fullest lives and become adults who are happy. Thank you so much again to all of you for coming, to Mr. Alexis Goff, Ms. Lisanne Taylor, and Ms. Michelle Russell. Thank you for accepting one's invitation and sharing your expertise with us. I thoroughly enjoyed it and learned so much, and I'm sure that our listeners enjoyed it as well. We appreciate you for sharing with us and for taking time out your busy schedules to join us this evening. Thank you to our listeners and participants who engage via our online mediums. I hope that the discussion gave you some insight and understanding of the laws governing incarcerated children in our region, as it was our aim to bring awareness to the issue. Thanks also to the UE Open Campus Marketing and Communications and IT teams for their technical support as usual. Thank you. And last but not least, thank you to our WAN team at the Women and Development Unit for the conceptualization of today's online forum, our head Taito Heron and support team member Renee Watson-Bell. Thank you. I invite you to follow the Women in Development Unit social media pages where you can keep up to date about our events. And you can find us at WAN UWI Open Campus. Have a great evening, everyone, and enjoy the remainder of your week. And remember what our panelists said, we need to decolonialize our minds. We need to do some brain scrubbing, as Lisanne mentioned, and that call to action in advocating for our children. Thank you. Good evening.